Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukar. This is a case relating to maintenance 125 crpc. Presently 144 of Bharatiya Nagarik Suraksha Sanhita. Why I am mentioning both these CRPs and BNSS is presently the case was dealt with under CRPC, but now the petition is filed for quashment under BNSS, Bharatiya Nagarik Suraksha Sanhita. Right. The name of Justice Manjari Shukla of Allahabad High Court. In the case of Dr. Virendra Kumar versus State of Uttar Pradesh and another, this is a revision, criminal revision number 6106 by 2023, dated 16/10/2024, held that or observed that when an allegation of adultery is made, definitely by the appellant, sometimes by the respondent, then before ordering for the maintenance, a finding should be made regarding the adultery. That means whether adulterous behavior of any party is proved or not. Without mentioning that finding, you cannot order interim maintenance. So this is what is stated by the Honorable High Court. If allegations of adultery are made in maintenance cases, these should be decided whether there is adultery or not. This is what is observed by Justice Manjari Shukla in this particular case. What happened? How this matter has come to the High Court, better understand. You know the Family Courts Act. According to Family Courts Act, it is a settlement court. ADJ will be there. He will try to resolve the disputes between wife and husband, and sometimes when it is not possible, according to section 182 of CRPC or section 24 of the Hindu Marriage Act, or sometimes Guardian and Wards Act, whatever it is, he will decide the quantum of the maintenance, basing on the relationship, basing on the necessity, basing on the circumstances, and the fact that when she or he is not able to maintain himself or herself. This is the original story. Here there is a dispute between Dr. Virender and Jyotsna Devi. His wife is Jyotsna. Here, family court ordered payment of maintenance of rupees 7,000 per month to Jyotsna by Dr. Virendra Kumar. He says, why should I pay the maintenance? His counter statement is that she is living in adultery with so and so. She is not having any conjugal relationship with him. She herself destroyed the family and things like that, he has alleged. The Honorable Principal Family Judge ADJ Cadre, Firozabad, he ordered interim maintenance Srimati Jyotsna, an amount of rupees 7,000, which already just mentioned. So in the reply or in the counter, Dr. Virendra Kumar categorically replied of her adultery. Now, he has raised a point which is mentioned in section 125 subclass 4 of the CRPC, which states that if the person is living in adultery, interim maintenance need not be paid to such person. Here, remember, it is only allegation. The Honorable Family Court, before ordering the maintenance, he should have inquired, he should have tried the matter relating to adultery. No doubt, the husband is put to strict proof regarding proving the adultery. He should have been asked whether he has got any evidence or not. If there is evidence, if there is enough evidence, no maintenance. If there is no enough evidence, definitely she has to be given the maintenance. That point is missing in the judgment or in the order or in the award of the family court judge. That means he is simply avoided. Very recently, I told you in one of my very 4 or 5 videos back, if you say, the judgment says the omnibus allegations of adultery, which cannot be proved or made, and it is not possible to prove them, therefore I am giving maintenance. But that observation at least was not made in the judgment. So, whenever you mention or allege under 125 clause 4 crpc, definitely they have to be proved. They are put to strict proof. So please remember, the High Court said, simply a bare perusal of section 125 crpc clause 4 says that when there is allegation of adultery, a recording of the finding should be there. They should have inquired. But that was not done. No inquiry was done under 125 clause 4 crpc. So the family court orders are awarding maintenance of 27,000 dated 13/4/2023 are hereby set aside, and the matter is posted to some date in November. Of course, they will continue the inquiry, because maintenance is one part here, the adultery is the other part. The important point in this judgment is, if there is allegation of adultery, it has to be ruled out. That means if there is adultery, no maintenance. If there is no adultery, definitely maintenance. Quantum is the discretion of the judge. So these 3 points are very, very important. I repeat, ఒకవేళ ఎవరన్నా ఈ మెయింటెనెన్స్ అప్పుడు నేను ఎందుకు ఇవ్వాలి, ఆవిడ వేరే వాడితో తిరుగుతూ ఉంది, బతుకుతూ ఉంది అని ఎలిగేషన్ పెడితే, అడల్టరీ అంటే ఆ అడల్టరీని ప్రూవ్ చేయాల్సిన బాధ్యత మీ మీద ఉంది. అడల్టరీ గురించి ఎంక్వైరీ చేయాల్సిన బాధ్యత ఫ్యామిలీ కోర్టు మీద ఉంది. అడల్టరీ ఎంక్వైరీ చేసిన తర్వాత అడల్టరీ నిజమైతే మెయింటెనెన్స్ అక్కర్లా, 125 clause 4. అడల్టరీ నిజం కాకపోతే మెయింటెనెన్స్ ఇవ్వచ్చు. ఎంత ఇవ్వడం అనేది జడ్జి గారి ఇష్టం. సో ఈ పాయింట్ మీద వచ్చింది కేసులో. So please remember the case law, read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.